that are friends who do financial type of work, it could be a presentation. And nobody can actually quite remember what the dates the presentation was and what was public information at that time. And therefore whether something should have been discussed at that presentation or should not have been discussed at the presentation. And frequently people's records, particularly when you're going back in a case that I'm doing at present, which actually is in 2005, and they can't actually remember, certainly the people who are instructing me from my side can't remember whether it happened between the 12th and the 15th of July, they think. And actually, you know, he's gone back to his diary, he's presented that as evidence, but it is quite relevant because there was so much going on in the wider world that actually had an impact on the case. And therefore, that may well be, and it hasn't yet come to actually trial, if it ever does, but it might be quite important for the judge to decide whether it happened before a specific moment when something was announced into the public domain. Okay, I think we probably flogged that one sufficiently now. Going on to the next slide is actually the memorandum itself. So this is now the first document that was without prejudice. This is your record, the formal record that goes out to the court, and of course is seen by both sides of solicitors and of course the barristers, who will tend to use it as to how they actually present the case. David can add something there. There is no format that you have to adopt, but actually I have found it often very difficult, particularly with complex cases, to agree how things are said and what is actually expressed in the expert's memorandum. I therefore have tended to fit into this structure because it makes it quite specific as to what you're actually putting down on paper. You know, you've already identified, hopefully, the points you can agree on. So it's quite possible to just put down under number 1, the experts agree. It was agreed that, yeah, such and such an investment was sold, the chronology was correct, and all the other bits and pieces that actually you can agree on. And then subsequently the points from the agenda that you disagree on. The experts disagreed that, and then you can just put down the agenda item. And then each of you can add a paragraph for which the individual expert takes responsibility for as to what your reasons are for disagreeing with his point of view. That the investment was correctly sold, that liability for the accident rested with so-and-so, or whatever it happens to be. And the important part here really is that you are taking responsibility for your paragraph, and the other expert is taking responsibility for what he puts in his paragraph. You are only responsible for your paragraph. Don't try and take responsibility for his, and don't try and belittle his argument in your paragraph, would be my suggestion, because it looks very poor by the time it gets to the judge 2 months later. Try and be absolutely bold in what you put, straightforward, and keep the sentences short. I have had one particular occasion where the other expert didn't like my paragraphs and refused to have them in the expert's memorandum. In fact, refused to sign it while my paragraph was there. It was actually a terribly simple situation, but it caused enormous trouble. What we were discussing was whether an investment was a complex or a non-complex instrument. Now, luckily, the FSA actually determined what makes something complex, or in fact 4 things that think it mustn't do if it's going to be non-complex. But he didn't like me putting in the FSA rules on which I was based. basing my argument. We resolved it by writing a supplemental report which gave the reasons and putting that to the court, which the other side then tried to veto, but the court decided it would accept it. And therefore, in the experts' memorandum, I just put, see supplemental report dated. And you couldn't really do very much about that. So anyway, I hope that's helpful. Do you want to add anything to that? Because you actually are a user of the joint memorandum when it comes
yes.
out.
There are, occasionally, I have seen joint statements which are rather like a stream of consciousness. And one expert will, well, and I said this during the meeting, and then the other expert, well, then I responded this. It's hopeless. It's difficult to follow. It rapidly descends into invective and debate, and as I think Thomas said earlier, it doesn't reflect very well on either expert. And the format that Thomas has suggested, whereby you set out the points upon which you can agree, and you identify the points in which you do not agree, and each of you then take responsibility for your short summary reason for your disagreement, and you don't attempt to argue out further or object to his reason. That is the format that I would endorse as the one that is going to be most useful to your instructing solicitors and ultimately to the court.
You've got the next one.
Yeah. Just to re-emphasise that the toing and froing of the joint statement before it's agreed, just like the discussions that you held at the meeting or on the telephone or however you conducted it, are both of them covered by what Thomas has referred to as without prejudice, and what the rule refers to as the discussions shall not be referred to at trial. Because until you have come to the final form of the joint statement, and each of you are satisfied with it and have signed it, then it essentially just forms an extension of the discussions that you've been having. Now, the next point gave rise to a discussion between Thomas and I whilst we were preparing for this talk, because in his draft of these slides, he included what is said there, that it's usually a good idea to share your joint memorandum drafts with your instructing solicitors. And I drew his attention to, or reminded him, because he was already well aware of, the guidance which is given specifically on this issue in another document. I've set this out on page 6 of the paper. There is a specific guide in the TCC, the Technology and Construction Court, to experts meetings. And what it says is this: whilst the parties' legal advisors may assist in identifying issues which the statement should address, those legal advisors must not be involved in either negotiating or drafting the expert's joint statement. Legal advisors should only invite the experts to consider amending any draft joint statement in exceptional circumstances where there are serious concerns that the court may misunderstand or be misled by the terms of that joint statement. And any such concerns should be raised with all the experts involved in the joint statement. Now, Thomas's response to this was that it is his invariable practice to share each and every draft with his instructing solicitors before he dispatches it off to the other expert. And whilst that is a practice which the court wouldn't criticise, it can only take place if you remember very clearly at every stage what your duties as an expert are. And of course you have to sign up to it at the foot of your report. You will repeat them at the foot of your joint statement usually. and that is that your primary duty is your duty to the court to advise the court on matters within your expertise, and that your evidence, which will include what you set out in the joint statement, must be the independent product which is uninfluenced by the pressures of litigation, and that you should provide at all stages an objective, unbiased opinion on matters within your expertise. And the danger is, particularly with a joint statement and the involvement of lawyers, that they will either overtly or subvertly, if you like, the rather unfortunate term, misuse of the English language, by subversion, they will influence what you're saying and remove your objectivity. And you've got to ensure that you retain that objectivity. And the point about sharing any involvement with your opposite number is again that if you have had discussions about the format of the joint statement with your legal team, which has caused amendments to be made, then and your opposite number doesn't know about this, then if you are subsequently cross-examined about it in court, and that's a salutary thing to be to remember at all stages. And I'll just tell you a little rule of thumb that we use in my chambers, and we call it the red face rule. And it's to do with anything that you do in legal practice. If you do something in legal practice that is brought up in front of the judge, and you would find yourself going red about what it is that you are having to accept that you've done, you have probably done the wrong thing. So always bear that in mind. If you are going to be embarrassed about something that you have done during the course of the preparation of the joint statement, then that is probably not what you ought to have done. Okay. Thomas, anything further?
No, I think that's great. Mace, we haven't had any questions. Actually, did we have one on the right there?
No, I came across exactly that situation where the other expert refused to sign the joint statement.
Yeah.
So, but you answered the question because that's exactly what I did. I put it in the supplementary.
Good.
Yeah.
Well, hopefully everybody else will be able to do that as well.
I don't
Yes.
understand how they can refuse to sign it if it's your statement, you're responsible for it.
Well, they can't possibly is the answer.
Yes.
They can't properly, but they can disrupt the whole thing and just say, I'm terribly sorry, I'm not signing it in that form. I don't like what you've written there. And I said, but this is the piece that I am taking responsibility for. Oh, well, you shouldn't be presenting the points there. Well, because we hadn't known it was going to be an issue of that sort, it wasn't something that had actually gone into the individual reports. But we dealt with it, and then subsequently, but if they had won the argument of not accepting the supplemental report, we would have been in great difficulty. Sorry, was there another one?
Yeah, sorry. I don't want to.
Do you want to just
encroach upon my
no,
time.
one more then?
But I had another example, because I was travelling after the expert witness meeting, right? So we agreed the other guy would draft it up. When I saw his draft, I thought this looks a bit strange, because it had some unusually legal expressions in it. So I then interrogated the properties of the document which I had received as an attachment. And it turns out it was drafted by the solicitors.
Yes, I've had that as well.
Yeah.
The metadata in the document is very revealing. If any of you know how to get to it, it's part of file properties on most Word documents. And it does show how long they edited